case Viramontes versus Cook County is at the U.S. Supreme Court. Ban has been put to conference for December 5th. This is just one of another case that could move forward to the U.S. Supreme Court soon, and that's the case Barnett v. Raoul, challenging Illinois' gun and magazine ban. It is Illinois in Focus Daily. I'm Greg Bishop with you each and every weekday morning, and we've been tracking the litigation against Illinois' gun and magazine ban since before it went into place, and even before that, there were bans regionally, like in Cook County. There was a ban on semi-automatic rifles and magazines over certain capacities, and an individual took that to court and went through the district courts, and then you have the state implementing its gun and magazine ban statewide. Viramontes included that in their challenge, goes to the appeals court. The appeals court sides with the state and the county, and now they've appealed to the U.S. Supreme Court, and this is a separate case from the Southern District case, Barnett et al., which had 4 different plaintiffs groups and had a 4-day bench trial on the merits of the law, and a district court saying that the law was unconstitutional. The Barnett case, again separate from the Viramontes case, is still in the 7th Circuit U.S. Court of Appeals with a hearing that happened on September 22nd, and here we are. Close to now 2 months fully after that hearing, and when are we going to get a ruling out of the 7th Circuit so we can anticipate fully whoever is the victor in that case, in the Barnett case, it's going to go to the U.S. Supreme Court. But before that, now we've got the U.S. Supreme Court's apparently going to consider the Viramontes case, and again, you can see the court docket at the U.S. Supreme Court's website. If you just search Viramontes v. Cook County, you will see that it was petitioned for writ on August 27th, shortly after the appeals court sided with the state in that case. You've also got, let me pull up here really quick, the actual ruling from the Viramontes case. You can see here the U.S. Supreme Court for the 7th Circuit saying that they brought this case with the Firearms Policy Coalition, Second Amendment Foundation, appealing the dismissal of their constitutional challenge to Cook County's assault weapons ban, relying on District of Columbia v. Heller and NYSERPA v. Bruin. They argue that the ordinance is facially invalid under the Second Amendment. Now, the appeals court, and this was back on June 2nd, when they made this ruling, they say that they addressed a similar challenge to the ordinance in a case that was before us on appeal with the denial of a preliminary injunction, and that was the Beavis case. By the way, the Beavis case, another regional gun ban challenge that also wrapped in the state gun ban, that stuck back at the district court after, on preliminary grounds, initial motions to halt the law as they deal with the merits. That made it all the way up and down to the judiciary, even going to the U.S. Supreme Court for consideration on preliminary grounds. But the Beavis case, again, separate from Viramontes, separate from Barnett, the Beavis case is stuck in the district court last I saw, and they're actually waiting for the outcome of other cases, including the Barnett case still in the 7th Circuit Court of Appeals, and the Viramontes case now possibly in front of the U.S. Supreme Court as they have pushed that to conference. But the appeals court goes on to say that they reject the challenge based on the record the plaintiffs have compiled at that early stage of litigation. The challengers have failed to develop a record sufficient to justify a different result. We therefore affirm. Cook County's ordinance prohibits the possession, acquisition, and transfer of assault weapons. The law applies to a variety of firearms, including semi-automatic rifles capable of accepting large capacity magazines and possessing certain features. So it goes on to explain more. This is not a first encounter with Cook County's ban. And Beavis, they said that the consolidated appeals in cases challenging Illinois state and local weapons bans, and Bruin, including Cook County ordinances at issue. We held the plaintiffs have failed to show at the preliminary injunction stage that the covered firearms materially differ from machine guns and military-grade weaponry. Again, this is some of the same stuff we saw from different appeals court cases, but this is what the Viramontes case is, right? It's the one that's now in front of the U.S. Supreme Court with the ongoing docket here showing that it's been distributed to conference for December 5th. What was the reply, right? Let's go ahead and check out the the actual motion and the petition here for cert. All right, so this is from the plaintiffs in this case, and they spell out, the question presented, whether the Second and 14th Amendments guarantee the right to possess AR-15 platform and similar automatic rifles. The parties, and spells it out who they are, the disclosure statements, and other proceeding matters. Then you get to the table of contents. Always interesting to just kind of quickly glance at what the arguments are. And they spell out constitutional and statutory provisions. And they say that Cook County's weapons ban extends to the most popular rifle in America. The ban's effects on petitioners explained, and goes on for reasons for granting the petition. So they're asking the U.S. Supreme Court, lower courts need guidance in applying Heller and Bruin. The issues presented in the case critically important. The decisions below blesses a ban on the most popular rifle in America. Under the rationale of the decision below, the Second Amendment permits anything short of a complete ban on all firearms, and the decision below irreconcilably conflicts with Heller and Bruin. They say Heller requires finding that the banned rifles are arms within the meaning of the Second Amendment's plain text, and history demonstrates that only arms that are both dangerous and unusual may be banned. And they say that this case is a good vehicle to address this question. Now, this is where we're going to get into a little bit of interesting back and forth, because you've got the Viramontes case, which did not have a bench trial, right? There's a lot of evidence and documentation, but it didn't have that bench trial building a even more substantial record. That was done in the Barnett case, and the Barnett case is still in the Seventh Circuit U.S. Court of Appeals. And the Barnett case that consolidated 4 different plaintiffs groups in the Southern District on preliminary grounds, it as well went all the way up to the U.S. Supreme Court, where the U.S. Supreme Court said they're not going to take the case because it wasn't ripe yet. It then went all the way back to the district court. Last year they had a trial, and then you had the Seventh Circuit Court of Appeals take up the district court's order that the ban was unconstitutional. So again, District Judge Stephen McGlynn in East St. Louis holding that 4-day bench trial, deciding that the law is unconstitutional. So now it's in the appeals court. The appeals courts held it for a bit. The plaintiffs had to say, hey, we're in limbo here. We have a judge order saying it's unconstitutional, but you guys are sitting on whether or not you are going to take the case and move forward with it. The appeals court then said, yes, they're going to have a hearing. They held the hearing, and then ultimately that's where we're at in the appeals court on the merits of the Barnett case. And it has a record that observers are acknowledging is a very strong record that they believe is exactly what the U.S. Supreme Court is looking for. So now we've got that still lingering in the Seventh Circuit. The Viramontes case may not have as strong of a record. That's what's being put forward to the U.S. Supreme Court. Now, I'm sure the U.S. Supreme Court, as they've done with other gun ban cases, they say, oh, we're not taking this one yet. We're not taking that one yet. Will they do that to the Viramontes case and say, hey, there's another case that's getting ready to get to us, the Barnett case, with a strong record addressing this question that the Seventh Circuit keeps bringing up about militaristic style firearms? They're too similar to military firearms. And if you recall that Barnett case, the 4-day bench trial, they had experts on both sides of the argument talking about the key differences between military firearms, not just from, having fully auto and burst and semi-auto, but also the metallurgy of the firearm is different from military grade versus the civilian metallurgy for consumer rifles that only do semi-automatic. But obviously a lot's been focused on the AR-15. Illinois' gun and magazine ban goes much further than the AR-15. It goes on to ban more than 170 different firearms beyond that too, when it comes to attachments and various different types of semi-automatic platforms, so including semi-automatic shotguns and a variety of other firearms. So what's going to happen here? It'll be interesting to sit back and watch. And of course, December 5th is the conference for the U.S. Supreme Court, and we'll find out if they put that in the orders list to go ahead and take up the case or to deny taking up that case in a way to ultimately go about waiting for the Barnett case. So we'll be watching. Of course, here with Illinois in Focus Daily, and get to thecentersquare.com. Sign up for the newsletter and wake up with us with those headlines in your inbox each and every day. And weekdays, be with us here for Illinois in Focus Daily.